Welcome to everybody. It's great to have you here with us on another Tuesday during the summer. We have a packed program for you again this morning. We have a couple of COVID-related topics which are unique these days, but I think that they're going to be helpful for you. All right, so let's start off with my COVID overview for this week, and we're going to look at current COVID data in New York State. Right now, we have, as of yesterday, the daily average for positive tests was 6,775. That's approximately a 12% decrease from over the past 14 days. That's good news. We're trending in the correct direction. Hospitalizations and ICU numbers are slightly up, but that's to be expected because that is a trailing statistic that we typically see at a certain period after a mini or large spike. Okay, next slide, Kathy. All right, current data. Again, we're going to look at the picture. This picture is always very helpful when it's dark, bright orange, not good. When it's yellow, good. We are looking at more yellow than we have seen in a while. New York City is in the surrounding areas is still a little bit more dark orange. We'd like to see those numbers increase or decrease a little bit. But as you can see on the chart to the right here, New York City has seen approximately a 18% decrease over the last 14 days, which is good. And surrounding counties on Long Island, Nassau, Suffolk, and surrounding areas, Sullivan, Orange, Westchester counties, we're seeing decreases, all except for Sullivan and Orange counties, well, slight increases. But the numbers are trending in the right direction. Next slide, please. I think it's helpful to do this every couple of months. We look at where we were and where we are. As of May 9th, you can see our daily case average was close to 10,000 per day, 9,500 approximately. And we saw some significant increases in upstate New York cases, Warren, Erie, Tompkins, Schenectady counties. So the numbers weren't looking that great in May, on May 9th. As of today, we're down approximately 3,000 cases per day, which is good. And we're seeing some numbers trending in the right direction. So positive numbers on the COVID front. As I do every time I give this update, no new regulations or rules that have been implemented by the Commissioner of Health. Nothing new to give you in terms of restrictions that employers have to go by, but I think it's still helpful to know the COVID landscape and where we are. Okay, with that out of the way, we are going to move to our first presenter of the day. It's Pete Jones. All of you know Pete. Pete's been on many, many times. Today, Pete is here to talk about accommodations relating to vaccine mandates. And this topic came up because Pete and I were discussing one of the new vaccines that was just approved for use and how it might impact some of these issues. So Pete, welcome. Good to see you.
Thanks, Adam. Good to be back on the webinar here. I guess this is sort of in the category of what's old is new, or perhaps what's old is old, but there are some developments here, and I think we thought it would be worth reviewing, where we've been, and also updating it for where we are now. So let's jump in here and just kind of go back and remind everyone of the general principles. First of all, we start with the principles of accommodation. We've been saying this since the very beginning, but the obligation to reasonably accommodate the known disabilities of employees under the ADA, the accommodation of sincerely held religious beliefs under Title VII, state law obligations in both areas should be really examined as well. We have, similar issues in higher education with respect to student concerns. And so, the general principles of discrimination law and accommodating known disabilities or sincerely held religious beliefs continues to be the overlay here. It's worth pointing out that there are, in many cases, some very simple things that you can do in the category of accommodation. And we've been doing these for, 2 years, 2+ years now. The social distancing, the masking, reduced density, is a real option and proven to be helpful. The video options and, other things that allow people to participate fully, or at least close to fully, and yet at the same time not be physically present. Now, there are aspects of this that might not be effective. And of course, a reasonable accommodation needs to be effective. So, sometimes in person may be required, for certain job responsibilities or, things of that nature. So not always will these simple options work, but they are certainly things to consider and things that are, oftentimes effective. There are also the more complicated options, or at least the ones that generally are more complicated. Things such as, working exclusively from home, changing of job responsibilities or altering job responsibilities, requests that have an impact on other employees or other students, in the context of, higher education. And so these get a little bit more difficult. Generally speaking, an employer doesn't have an obligation to eliminate the essential functions of a job. So, to the extent you're talking about changing job duties or doing something different, the question would be, are they essential functions or are they marginal functions? So these are the ones that get a little bit more complicated. And the ones that, frankly, all of us have been working through on an individualized case-by-case basis for the past several years, at least with respect to COVID. Okay, so winnowing it down a little bit or focusing a little bit more to the vaccine, mandate piece. We have seen, of course, government mandates, and we've also seen, various challenges to those, and they are in various postures in terms of where we are. But I think we're mostly talking here about employer mandates. And, to the extent that an employer has a vaccination requirement in place, or at least a requirement that somebody provide proof of vaccination or some sort of other package of accommodations would be offered, that we are going to face, and we have continued to face, requests for accommodation of medical conditions, requests for accommodation of religious conditions. And the first thing on the medical side would be to evaluate the condition and whether it is in fact, inconsistent, with the vaccination. And the word that the literature uses here is contraindicated, that the vaccine may be contraindicated by the employee's condition. You may need some help with this. Some medical experts, somebody who, on an outside panel could help you, or on a consulting basis could help you, to the extent that, we're not all medical experts, which most of us aren't. But then, assuming that there is an obligation to accommodate because there's an issue with vaccination for the individual, we would be looking at, what sort of package of things would we put in place to ensure the safety in the workplace, ensure the safety of this particular worker, and also at the same time waive or agree to accommodate the request. And so we're talking about, again, masking, testing, social distancing, etc. Put a little pin in the testing because I want to talk a little bit more about that in a second. The other thing that I think we can do and should do is evaluate, if the condition may change and the vaccine could become appropriate. For certain conditions, let's just say an allergy to vaccine components, that's not going to change. But for other conditions that are not static, a vaccine may not be appropriate at one point in time and might become appropriate later. Similarly, on the religious accommodation front, we're looking at the standard here is whether the individual has a sincerely held religious belief. Generally, it's going to be rather difficult to challenge that sort of thing because, if the individual states it and can articulate it, it may be difficult to say, well, that's not sincere or it's not real. Where we get into the more the beef of the analysis is whether that there's a more of a de minimis burden to the accommodation. But if the accommodation is going to be granted, then we would be looking at the same kinds of things that we look at in an ADA situation. What package of masking or waiving, testing, etc. Would be appropriate. So just a word on testing, and I know we covered this a couple of weeks ago in the webinar, but for those of you who weren't there, or even if you were there, hopefully this will be sort of a helpful review of the way to think about it. But the EOC has gone from a more deferential standard because of the, I'll call it, raging pandemic, to perhaps more of, if we're hitting an endemic stage, saying, look, we're going back to the job-related and consistent with business necessity standard for COVID testing. And they have said in that, guidance that that will be evaluated against, guidance from the CDC and the FDA and state and local, public health authorities. And so I think the thinking there is that not that testing is not appropriate, or that this standard can't be met, but that it requires a more individualized analysis, which frankly, we're already doing in these ADA and religious accommodation cases. But the factors to be listed give you some insight into what their thinking is. I don't know that we're going to know how these cases come out. The frustrating part is we're not going to get an answer, until a year or two hence, right? So the one thing I would urge you to do, if you're going to consider and require testing, is to document these factors. Take a look at what's on this slide, which is taken right out of the guidance, and say, based upon, whatever it is, the level of community transmission, the vaccination status of our employees, et cetera, for right now, we are making this decision. And we're making this decision on that basis, and we're going to review it periodically. So we'll see where this goes in terms of, challenges. I think we can predict, based on what we've seen, that there will be challenges. So I would urge you to review and document these factors if testing is going to be a component of your reasonable accommodation package. Okay, so that's kind of where we've been, and up to a couple of weeks ago with the EOC. We also wanted to talk a little bit today about what's out there in terms of the vaccines. And there are now 4 vaccines that have been approved by the FDA for at least for emergency use authorization. And the 4 are the familiar ones that we've been talking about for quite some time now: the J&J, the Moderna, and the Pfizer. Okay, but it's interesting, and I took this information that you see on this slide straight from the CDC website. I'm not a vaccine expert, but there are 3 different technologies that are in play here. The J&J is a viral vector vaccine. The Moderna and Pfizer is an mRNA, which I think we've all heard, a fair amount about that. But the recently approved Noravax is a protein subunit vaccine, so a 3rd different kind of technology. And I think the thinking here, at least our thinking, is that if people have objections, whether they're objectively based or subjectively based, to a particular kind of technology, that the 3 different vaccines might open the door for some people who've been vaccine hesitant. And so Noravax certainly has something to add in that context, because it's a different kind of vaccine technology.
Pete, if I can jump in for a
Sure,
second.
absolutely.
So one of the things that we've seen recently are doctor's notes. Sometimes we assist clients with evaluating accommodation requests. And we've seen some doctor's notes that say this particular individual cannot get an mRNA vaccine. So up until now, you have J&J, but people are concerned about J&J and blood clots. So the Noravax presents a real opportunity for you, if you are mandating the vaccine and you have someone who has a doctor's note that says they can't get an mRNA vaccine, Noravax now provides that solution. So potentially. So that's something to think about.
Yep. And, with respect to all of these, the CDC website says, they don't contain, eggs and preservatives and latex and metals. But there is a possibility that, the list of ingredients for each of these might tie to something that a person is allergic to. Generally speaking, I don't think a history of anaphylaxis is considered enough to say that, that these are, contraindicated. Maybe for some physicians, it may be a red flag, but, generally speaking, I think the drill down to what the components of these are is preferred from a medical perspective. The last thing I would mention, and again, Noravax is a little bit different. Noravax has indicated publicly that fetal stem lines are not involved in the development of this vaccine. And so that may help with religious objections. So I guess it, remains to be seen, how that will play out. But the interesting thing, I guess, about the Noravax vaccine is that it may present some new opportunities here, as Adam says, for people who have been vaccine hesitant or who have outright objections from a religious basis or a medical basis to now get the vaccine. So that's really all I had today, Adam, unless there's anything else you want to add in.
That's great. Just one correct. It's Novavax, not Noravax. So that's my fault, typo on the transcription of the slide. So I apologize. But that is the new vaccine is Novavax. Okay, well, Pete, thanks so much. I think that's very helpful. And I know that a lot of you, especially those of you in higher education at this point, are going through these accommodation requests quite a bit. So feel free to reach out to any of us if you have any questions. We've been working through these with clients for the past 2.5 years now. So, well, no, the vaccine didn't come out 2.5 years ago. So I'll correct that. But thank you again, Pete. Good to see you. Okay. Next up, we have Kirsten Barclay. Kirsten has presented on this webinar before. Kirsten is one of the attorneys in our school law practice group in Rochester, and she is going to give us an update on New York's school vaccine requirements. Kirsten, welcome.
Thank you. Thanks for having me. We wanted to just give an update on the school vaccine requirements. If you're already familiar with the school vaccine requirements for K-12, pre-K-12, I think the biggest takeaway for you from this is that nothing is changing going into fall of 22. But there have been some recent developments in the courts, and so we thought we would just give you a broad overview or a refresher on vaccination requirements. And then, just share some of the more recent court decisions. Next slide, Kathy. Great. So, as you probably know, mandatory vaccines have been required for children ages 2 months to 18 years old if they're going to be in school. And it does not matter what kind of school they're in. So if even a 2-month-old that's going to go to a daycare center has to have their vaccinations. Before 2019, there were 2 exceptions to the vaccination requirement. The first one was a medical exemption, and for the medical exemption, a physician needed to submit a signed written statement or give that to the parent. And the parent would take that to the school official for review. And generally speaking, most of those medical exemption physicians' notes that we saw kind of applied to all the vaccines and oftentimes did not provide a lot of specificity with respect to what kind of contraindication was why the child could not have the vaccine. And it also didn't give kind of a length of time. So when school officials received those medical exemption requests, for the most part, they would grant them. The second exception was a religious exemption. And like for employees, it was the same standard. So parents simply had to articulate that they had genuine and sincerely held religious beliefs in order to be exempted from having their children vaccinated. So in 2019, you might recall that New York had a measles outbreak in some specific counties, many of them downstate. And what the data showed was that in those areas where there were relatively low rates of vaccination, there were high rates of measles. And that led the New York legislature to try to strengthen the public health protections. The amendments to the statute in 2019 did a couple of things. One, they imposed stricter criteria and a more stringent process for getting a medical exemption. And they also, importantly, eliminated religious exemptions. So again, that's another big difference between an employer analysis and a student analysis in a school district. Next slide, please. So the religious exemptions, the legal challenges to that were brought in Albany State Supreme Court in 2019, and the plaintiffs argued that they were being discriminated against based on religion, and that the mandate or the removal of the religious exemption violated the free exercise clause of the First Amendment. That state Supreme Court, which is the first level of courts, relied on two pretty important cases for finding that free exercise does not mean a person can violate a valid and neutral law of general applicability. And so that means that you can exercise your religion freely until it imposes some type of burden. So the two cases that the state court relied on were a US Supreme Court, a pretty old one. In 1944, the Supreme Court looked at this issue and said plainly that a parent cannot claim freedom from compulsory vaccinations on religious grounds. And a right to practice religion does not include the liberty to expose the community or a child to a communicable disease or ill health or death. And the court also noted a Second Circuit decision from 2019. And in that decision, the Second Circuit said, New York could require vaccines for all kids, but they go above and beyond what the Constitution requires by allowing this religious exemption. This decision was appealed to the Third Department, which is a state appellate court, in March of 21, and that court affirmed the decision. And then after that, the plaintiffs sought leave to appeal to the New York Court of Appeals, which is the highest court in New York. That was denied, and then they filed for a writ of certiorari to the Supreme Court, and that was also denied. So this is now considered to be settled law, and the religious exemption no longer exists, and that is the way it will stay until the Supreme Court perhaps decides to revisit it. Next slide, please. I just wanted to show you a map of religious exemptions in the country. And so what you can see from this map is that the vast majority of states in the United States and territories have some type of religious exemption or personal belief exemption. And the states that don't include, in addition to New York, are Connecticut and Maine and California, and then West Virginia and Mississippi. So I think a very different kind of reasons perhaps why the different states have made those choices. But it'll be interesting to see going forward whether other states consider eliminating the religious exemption. Next slide, please. So as I mentioned, the other exemption that existed prior to 2019, but which has now been made more rigorous is the medical exemption requirement. The rules for this, according to the New York State Department of Health, is that a physician has to certify that a child has a medical contraindication or precaution to a specific vaccination. So not all vaccinations, unless that is in fact correct. The information from the doctor has to contain sufficient information to identify what that medical contraindication is. It has to identify the specific immunization, and it needs to specify a length of time that the immunization is medically contraindicated if the doctor feels there is at some point that the child will be able to eventually get the vaccine. There's also now a specific form that has to be used by physicians. For our school district clients, you will be familiar with this form. I'll show you that next. It's the same form that has been in use since 2019. The other thing that the State Department of Health said is that the doctors have to follow the guidelines of the Advisory Committee on Immunization Practices, which is a committee under the Center for Disease Control, or another nationally recognized evidence-based kind of body of thought. Next slide, please. So this is wanted to just show you the form, and what you can see is that the form notes where the doctor can find the guidance for contraindications and ask them to look at the most recent guidance. The doctor can also rely on the vaccine manufacturer's package insert. And then you'll see the doctor has to check off which of the vaccines the child cannot have, along with the date that the exemption ends, if applicable. Next slide, please. So these definitions of what the doctor needs to look at are pretty stringent. First of all, there's this contraindication definition, which means that the child has a condition that kind of like definitely increases the risk for a serious adverse reaction. And so some of the examples of that really have to do with immunodeficiencies and being immunocompromised, or having a severe allergic reaction after a previous dose. The other standard that the doctor can rely on is a precaution, which means that the child has a condition that might increase the risk for a serious adverse reaction or cause diagnostic confusion or compromise the ability of the vaccine to produce immunity. And examples of that include if the child has an acute illness at the time, or there is a personal or family history of seizures. Next slide. So this also has been challenged in the U.S. District Court for the Northern District of New York. And the challenge was brought by a group of parents who basically they kind of collected parents who had either had their exemption request denied by school officials on the basis that it lacked sufficient detail, on the basis that it did not meet those ACIP guidelines for the contraindication and precautions, or that the parent submitted the exemption request on the wrong form. So not that form that I showed you earlier. And so they argued that their 14th Amendment due process rights were being violated, and they listed some alleged fundamental rights, substantive due process rights, right to parenting, right to informed consent, and burdening a minor's right to pursue education. And then they also raised claims under the Rehabilitation Act. Most schools know that as Section 504. And so there were some disability discrimination claims. The district court granted the state and school districts motion to dismiss that case. And the Second Circuit, when district court grants a motion to dismiss, reviews the record as if it is serving in the role of the district court. So reviews the whole entire record again. And the Second Circuit on Friday affirmed the district court's decision to grant the motion to dismiss. So the only place this case can go at this point is up to the Supreme Court. And so if these parents decide to seek a writ of certiorari, we would wait and see whether the Supreme Court would hear the case. Next slide. So just want to talk through some of the interesting holdings from the Second Circuit. The first one, which I think people really find surprising, is that there is no fundamental right to an education. And I think we've seen that historically and very consistently in case law in the United States, and most people are surprised by that. The court did not like the parents' argument that the school district should have to rely solely on the recommendation of the physician. They rejected the idea that there was some fundamental right for a physician to say that a child is exempted. The court also held that the new regulations still allowed for medical exemption, right? But that they narrow that availability and clarify when an exemption is appropriate and how parents have to seek that exemption. And they also pointed out that the purpose of the regulations is to ensure that the risk of harm to a child from a vaccine is genuine. So I think that's in response to data that really shows in states that have increased the rigor of the screening for medical exemptions, the vaccination rates have significantly increased because doctors are more hesitant to write these notes because they really have to drill down into exactly what the child's medical condition is. And the Second Circuit finally affirmed that school officials have broad discretion to enforce health laws. This is not something that sits particularly well with our school district clients because, as you can imagine, they are not experts in medicine. And so it was good to see that the court affirmed that that is within their discretion. But I think, this is one of those areas that you should consult with your district's physician or your counsel, just so that you are making an informed decision. The last thing I'll say for the few school districts that have ended up with challenges to their decisions, those are pretty expensive defenses to defend their position that the exemption does not meet the requirements. So that's, excuse me, that's just another thing for districts to think about. I do want to say, just lastly, oh, I'm sorry, can you go on to the next slide? Sorry. Oh, okay, thank you. So I want to address the Rehabilitation Act, the discrimination claims. The court, the parents argued that the kids were being discriminated against based on disparate treatment, disparate impact, and failure of the district to make a reasonable accommodation. The court pretty strongly said that the parents failed to allege an exclusion based solely on the child's disability. And some of the rationale the court reminded us of is that in these exemption cases, all students have to comply with the vaccination requirements, not just students with disabilities. It also pointed out that the new regulations don't bar students from school because of their disabilities, because students who actually have a medical need are going to be granted an exemption. And then the last thing I'll say is that the court pointed out that the parents here, that the kids here were not excluded because of a disability, but really were excluded because the parents failed to comply with the new procedures. So I think that bodes well for districts worrying about disability discrimination claims under the vaccination requirements. And I think also, you know, that these disability discrimination claims are more individualized. So if you do get a parent alleging disability discrimination based on a denial of a medical exemption request, I suggest you contact your counsel. So with that, I will wrap it up, Adam.
Kirsten, thank you so much. And if anyone on here has any school district related questions, please feel free to reach out to Kirsten or anyone in our school practice group. All right, last but not least is me. I am going to be giving a brief presentation on discipline and discharge. I will tell you that what I typically present on during these webinars comes from what I'm hearing the most in my practice. So what questions am I getting a lot from clients? And for whatever reason, I've been getting a lot of questions over the past couple of weeks about appropriate discipline and potential discharge of employees. So let's talk about that for a minute. Okay, so we had Lou DiLorenzo and Jeff Keel on, I want to say a couple of months ago, and they talked about the at-will doctrine in New York. So generally, what is at-will? It means that absent an employment contract for a definite period or a collective bargaining agreement, you as the employer can terminate an employee for any reason or for no reason. Next slide. And as Lou explained, though, there is an exception to this at-will employment rule that essentially swallows the rule. So yes, you can terminate anyone for any reason or for no reason. However, you cannot terminate someone for an illegal reason. And the list of what may constitute an illegal reason is long and it is detailed. So next slide. So here are some of the examples of illegal reasons. What are some of the illegal reasons you can't terminate someone for? Based upon their age, you can't terminate or discipline. Based upon their age, their criminal history, disability, marital status. I'm not going to read them all, but you can see there are a lot of things that you can't take an adverse employment action against someone because of. Essentially, every one of your employees is likely going to fit into at least one of these categories. So, yes, New York is an at-will employment state, but you can't terminate someone because they are within a protected category or they engage in protected activity. You see the retaliation category here on the right. So you can't terminate somebody because they are a whistleblower. You can't terminate someone because they exercise their rights under various statutes, such as the Family Medical Leave Act or New York's Paid Family Leave Law. So yes, everyone's at will, but no, you can't terminate them because of or for any one of these reasons. Next slide, please. So how do you protect? One of the ways that you protect the at-will relationship with your employees is you make sure that you state in your handbook or whatever documents you provide to your employees at the inception of their employment that they are general guidelines. It's not a contract of employment. There is good case law in New York State that says if someone tries to sue you as an employer for breach of contract and you don't have an employment contract with the individual, if you've told them that the policies included in your handbook are not a contract, then the employee cannot rely on the contract or cannot rely on those policies to state a claim for breach of contract. So you want to make sure that you, in your handbook, you disclaim that the handbook is a contract. You also want to reserve your right to supplement, modify, or abolish any policies that you might have in your handbook. You want to state that employees are employed at will and they can terminate their employment for any reason. That's another way that you maintain that at will status. And you make sure that you state that no other agreement or assurances have been made during the recruiting or the hiring process. What you don't want is someone to come back and say, you told me when you were interviewing me that I was going to be employed for a particular term and that we were going to have an employment contract. You want to try to avoid that altogether. Okay, next slide, please. So when you're faced with a claim, so you take an action against somebody and they come back at you and say, you're discriminating against me because of X, or you are retaliating against me because I did Y, the best defense to that claim is that you followed the just cause standard. So for those of you who are HR professionals in the audience right now, you all have heard of just cause, and you probably have heard of the 7 tests of just cause, but I'm going to go through them with you quickly now. Next slide, please. All right, so these 7 tests of just cause are the way that you establish that whatever adverse employment action you're taking, discipline or discharge, is unrelated to somebody's protected characteristic or protected activity, but rather you have a very good reason for the action that you're taking. So the 7 tests are, number 1, notice. Did you put your employee on notice of whatever the rule is and the possible consequences for violating the rule? If you are in a manufacturing setting, you may have work rules. Work rules say you can do X. If you don't do X, safety, let's take a safety precaution as an example. You fail to wear particular safety equipment, you may be subject to the following penalties. That's notice. Did you notify your employee about the rule and what might happen if they don't follow it? Was the rule reasonable? Was it reasonably related to the orderly, efficient, and safe operation of your business? Taking that safety rule as an example again, that is clearly related to the safe operation of your business. The third rule, third step, I should say, investigation. So you believe someone has violated a rule that you have as an employer. What have you done to investigate it? Have you talked to the person? Have you talked to any other witnesses? Have you gathered documentary evidence? There may be some of you on the call now who remember we put on an in-person 3-hour training on workplace investigations. Those can be very detailed or they can be very, very short. But when you're dealing with just cause, was there an investigation? Next slide, please. Number 4, was your investigation conducted fairly and objectively? Did you talk to the right people? Did you gather the right evidence? Number 5, proof. What proof do you have that the employee engaged in the prohibited conduct? And is it good and solid proof? Are you treating employees equally? This is something that we see a lot in discrimination cases or retaliation cases. So-and-so engaged in similar conduct and you didn't discipline them. You didn't terminate them. So you want to make sure that you are applying the rule even-handedly, treating similarly situated employees similarly. And finally, the last step is there an appropriate penalty? Did the penalty fit the crime? Was the level of punishment appropriate for whatever the infraction was? Next slide, please. So on that point of making the corrective action fit the offense, you want to consider what is the nature of the offense? Is there a prior disciplinary history? What is the length of service of the individual? Are there exacerbating circumstances? Past practice, what have you done with other people? And what does our employee handbook say? Is there a prescribed penalty in the employee handbook? You got to think about all these things when you're working through the proper and appropriate corrective action. Next slide. So we've all heard of progressive discipline. What are the steps in progressive discipline typically? You usually go from a verbal warning to a written warning, to a final warning, to a suspension, and then to a discharge. I'm not here to tell you that you can't skip steps. That's certainly not the case. Certain conduct may warrant you jumping immediately to termination. It just depends on the circumstances. These are the typical progressive discipline steps, though, and should provide you with some options when you are making the decision about what is appropriate in terms of discipline. Why is progressive discipline important? Because it's how you correct the employee's problem. You're sending a message to coworkers, if the problem is not corrected, that you would tolerate certain conduct that you don't necessarily want to tolerate. You provide credibility for your supervisors. And the most important thing that I typically run into is you're defending legal actions against the company. So if you come to me with a lawsuit that says this person is claiming they're being discriminated against, the first thing I'll say to you, okay, what did you do? I terminated them. Well, why did you terminate them? Well, here is why. I have documented X, Y, and Z. Here's the rule. Here's the investigation. Here's what we found. Here's how we've handled it in the past. If you say that to me, that's an easy case. But not following those steps can get you into legal trouble sometimes. Next slide, please. So there are some variables when you're determining what discipline is appropriate, including the number of verbal warnings, written warnings, etc., and other history related to the individual's performance. In a factory setting, manufacturing setting, in other settings, it's sometimes common to have discipline go away or be taken off of the employee's record after a certain period of time. That's something that you should consider and make sure you are paying attention to when you are administering discipline. Are there rules in our handbook or in our collective bargaining agreement that tell me what I can do and when I can do it? Next slide, please. Okay, next slide. I already covered this. Okay, so this is my final point to you with respect to discipline and discharge. Documentation is key. And I'm coming at it from the other end where I'm having to defend claims of discrimination, claims of retaliation, where I have documentation from the client, where you have a good track record of here's why we did X, Y, and Z. It is always easier to defend those cases. Some types of documentation that I'm talking about, performance evaluations. If there are issues with somebody, I get calls a lot that say, we want to fire this person. Okay, why do you want to fire them? Well, they haven't been doing a good job with their performance. And the next question that I will always ask is, okay, do you have any documented discussions, documented issues with the performance? Well, no, it's just been going on for a long time. Well, that's okay, and we can deal with that in litigation, but I'll tell you it's always much easier if there is a paper trail regarding things like performance. Discipline documents, make sure you keep those in the employee file, investigation reports, etc. So documentation is key when you are disciplining and you're discharging. Make sure that you, well, I would say our recommendation to you is that you follow the 7 steps of just cause whenever you're taking any employment action. It is the safest course of action because you don't want to have to call me if you don't have to. So we appreciate you being on today. Keep those suggestions for content coming. Here is our contact information. Great to see you all. We will see you next Tuesday.